Then, so to begin, okay, the outline, you will follow it. To begin, I would like to give some general overview concerning the General Court and its activity in trademark cases. So first of all, the totality of the trademark cases brought before the General Court are concerning the appeals of the EU IPO's Board of Appeal cases. And that explains maybe why our cases are a bit mechanical, as we heard yesterday. Then the other thing is that, unlike the Court of Justice, we do not deal with the preliminary rulings. And as concerning our general activity, I would say that the background picture given by Judge Lesich applies to a big extent to the General Court as well. So statistically speaking, the trademark cases, these appeals from Alicante, account for more than one-third of all the trademark cases for already some years, and it's the same tendency this year. And although in the examples I have selected for this presentation, the General Court has mostly annulled Boards of Appeals decisions, I should point out that the general rate of annulments is rather low, and it's a bit more than 10%. And as for the language of the case, most of the cases are in English, then followed by German, and quite surprisingly Spanish, because concerning the other types of cases, it's not to the same proportion for the languages. I may be very optimistic because I have 10 judgments for this morning, but let's see how far we go. Maybe they are not the most groundbreaking judgments, but at least I think they cover the main questions and notions we have seen here yesterday and also in this morning. And as the new secondary legislation concerning the procedural matters will enter in force in a couple of days, I decided not to talk about these matters because it would not be of much interest, at least partly. So first of all, in the last year, for the past 12 months, the General Court has had the opportunity to deal with bad faith in several of its judgments. And to remind you, the notion of bad faith is contained in Article 52(1)(b). It will become Article 59 as from Sunday. And the article says that if the applicant of a trademark was acting in bad faith while it filed the application, the mark shall be declared invalid. So the Court of Justice has given some general framework how to appreciate the bad faith. First of all, the relevant time to assess the existence of bad faith is the time of filing the application. And it's up to the third party who is relying on the bad faith of the applicant to prove it, because otherwise, generally, the good faith is presumed. It should be noted that the concept of bad faith is not defined in the legislation. So, as you have noticed for sure in many trademark cases and principles, all the relevant factors has to be taken into account, and these factors are in particular the knowledge by the applicant that an identical or similar mark has been used by a third party, but it also includes a general knowledge, then the applicant's intention to prevent that third party from using its sign, and of course as well the degree of protection enjoyed by both signs at stake. But also can be taken into account the origin of the sign, its use since creation, the commercial logic underlying the filing, and chronology of the particular events leading up to the filing. And as you will see, sometimes it may play a role. So the first case for today is concerning a former Polish professional boxer, Dariusz Michalczewski, known by his nickname Tiger. And he concluded 2 agreements with a company called Food Care concerning the use of his image, nickname, and word and figurative trademarks in order to promote the marketing of energy drinks, the packaging of which will comport the sign Tiger. And under that agreement, the Food Care marketed energy drinks with the following packaging you can see on the slide. And I draw your attention especially to the last can, how it is presented. In 2008, Food Care registered an EU word mark TGR energy drink for beverages and their ingredients. Mr. Michalczewski filed an application for invalidity, which was based as well on bad faith argument. The Cancellation Division rejected the request, stating that the Food Care's bad faith was not proven at the moment of the filing. And the Board of Appeal, on the contrary, considered that there was existence of bad faith and annulled the decision. The General Court upheld the decision of the Board of Appeal, and first of all, it stated that the 2 agreements left no doubt as to the knowledge by Food Care that the sign Tiger was owned and used by Mr. Michalczewski. Then it observed that the contested mark can be seen as a modified version of the sign Tiger, and the same is true concerning the sign Tiger energy drink. And as you see on the packaging, so this sign TGR energy drink became somehow quite similar with like a tiger scratches. And so this similarity, according to the General Court, shows Food Care's intention to create in the mind of the consumer, if not confusion, at least an association between the contested mark and his own marketed products. And the General Court reached the conclusion that by filing the application for the contested mark, Food Care actually intended to continue benefit from the reputation enjoyed by the sign Tiger energy drink while circumventing the contractual obligations. So it confirmed the position of the Board of Appeal that Food Care's intention was one of the relevant factors in assessing whether it had acted in bad faith. The second case is a bit more complicated. Facts are very simple. A company called SindustryServe filed an application for registration upon air-hole face masks request. But it did it in its own name. And so the question that's raised before the EU IPO and the General Court is whether that request for filing included the filing of the mark in the name of SindustryServe or in the name of air-hole face masks. The Cancellation Division found that there was a bad faith on the part of SindustryServe, and so declared contested mark invalid. The Board of Appeal annulled that decision and considered that the mark was filed with the consent of air-hole face masks. And the 2 elements of the reasoning of the board were the fact that the SindustryServe knew that the mark was already in use was not in itself sufficient to establish bad faith on its part. And secondly, that there was no evidence that it had the intention to use that mark against air-hole face masks. The General Court took a different view. First of all, it considered that in the present case, air-hole face masks did not consent in a clear, specific, and unconditional manner as to the filing of in the name of Industry Surf. Then it considered that the Board of Appeal should have assessed the matter of the applicant's consent in the light of all the objective circumstances of the case, which are, for example, the fact that an identical trademark was used in the United States and Canada by the parent and sister companies of air-hole face masks, the existence of a distribution agreement between the two parties, and third, that the contested mark or the filing of the contested mark could be perceived as being part for air-hole face masks, a part of a commercial logic to expand its trademarks protection to the EU. And the General Court also found that the General Court also found that the trademark owner, by filing the contested mark in its own name, sought to usurp applicants' rights. And in addition to the elements that I already mentioned, it pointed out some circumstances. The fact that Industry Surf did not inform air-hole face masks about the filing or the registration of the contested mark in its own name. Afterwards, it undertook to transfer the mark, but never did it. And when the relations between the parties had deteriorated, it issued a notice to cease using the contested mark to the air-hole face masks. So the General Court concluded that Industry Surf did not have any lawful reason to file the contested mark in its own name, and thus the Board of Appeal was wrong in finding that there was no bad faith on its part. The following case is PayPal against the EU IPO. And on the one hand, we have a company called Hub Culture, who is using a virtual digital social currency called VEN. It also has a registration for wordmark in the United States, covering the financial services in class 36, and as well the domain name venmo.net. On the other hand, we have the company called Venmo, who is providing online payment services in the United States under the unregistered trademark Venmo. So the first company, Hub Culture, expressed to the second one its worries that there might be a likelihood of confusion between the two signs. There was a meeting between the representatives of the parties. No real agreement was reached, but in the meantime, the first company decided to make an application for the EU wordmark, Venmo, although its sign was Ven. And so afterwards, the owner of Venmo filed an invalidity request. So the cancellation division declared the mark invalid, and considering that there was that the pre-contractual relationships that existed between the parties allowed to expect that Hub Culture will not file an application for an EU mark without giving the other party a prior notice. And secondly, it considered the mark that the mark was a defensive one. That decision was annulled by the Board of Appeal, who considered that although the Hub Culture was clearly aware of the use of Venmo as an unregistered trademark and corporate name in the United States, the bad faith on its part could not be established. And the main argument of the board was that the registration of the sign Venmo could be seen as a logical commercial trajectory for the Hub Culture, as it was owned already the Ven trademark and the domain name venmoney.net, and that Venmo could be seen as an abbreviation of Ven Money. And it also took into consideration the fact that there was no evidence proving that the Venmo sign was used for a long period, that it was legally protected or well known. The decision was appealed to the General Court. The General Court first agreed with the board that the knowledge in itself was not sufficient to conclude that hub culture was acting in bad faith, but it considered that the Board of Appeal analysis was not based on all the relevant factors, and mainly that what the General Court said or disputed that conclusion of the Board of Appeal concerning the commercial trajectory, and considered that there was no plausible commercial logic as why hub culture should register the contested mark, and it pointed out that the use of sign when money has not been established, and that none of the hub culture's right could took actually the abbreviation of Venmo. And so the court concluded that intention to prevent a third party from marketing a product may, in certain circumstances, be an element of bad faith. And as the Board of Appeal decision was not based on all the on an analysis of all the relevant factors as required by the case law, that the decision got annulled. Okay, there are two other bad faith cases. In these ones, the bad faith was not established. The one was mentioned as well yesterday, the Cipriani case. So let's turn to the absolute grounds of refusal. And this case concerns the qualification and the perception of the trademark. And if the new regulation was already in force, maybe we couldn't get this case because of the rules concerning the graphical representation. So the market issue, you can see it, and it was registered for knitting needles and croquet hooks. And there was a request for invalidity made by Crafts Americana. And the cancellation division considered that it had a distinctive character. The Board of Appeal, on the other hand, considered first that the market issue represented a pattern placed on part of the goods or covering the whole their surface. But in order to identify the essential characteristics of the contested mark, the Board of Appeal took into account the photographs and samples of the goods marketed by Indeutsch, which were in the file. And it concluded, so these are the photographs. So the mark was like that, and the photographs are like that. And the Board of Appeal concluded that the contested mark will not be perceived as an indication of commercial origin of the goods at stake, but either as a decoration for these goods or having appearance of wood grain, the material from which the goods concerned are made. The General Court annulled that decision and took a different view. And first of all, it not on the main question, but rather on the proceedings. The General Court reminded that the distinctive character of the mark must be assessed as it was registered and as it appears in the trademark applications, regardless of how it is used. And it found that in the present case, it cannot validly be maintained that the market issue will be perceived as a representation of detail or aspect of the goods that covers, and even less that it was a shape mark concerning these knitting needles. And it also noted that the patterns on goods in question differed from the mark of the applicant in a non-negligible ways. First, there were colors. Secondly, the intervals between these chevrons were irregular on the mark, how it was used, although it was completely regular, an abstract geometrical shape in the mark that was registered. And so the General Court concluded that in order to examine the distinctive character by relying on these examples, the Board of Appeal actually did not it was not a part of the process of identifying essential characteristics of the mark, but rather it was an alteration of those characteristics. Then, the following case, you might wonder why I have included it, because it's a quite straightforward case, but the interest of that is the possibility to register as a EU trademark the words that are in another language. And so in this case, the word medvedya, meaning bear in Russian, and so the cancellation division rejected partially the application, concerning that it will be descriptive for the goods related to or containing meat as well as live animals. The most important, so as I said, is the possibility to register or not the words in other languages, and the General Court stated that the application of Article 7.2 is not limited to the official languages of the EU, and that absolute ground has to be examined regarding all the languages understood, at least in the part of the EU, and so the relevant public in this case would be the Russian-speaking population of the EU. And then it found, as the Board of Appeals, that the sign will be, it will describe the dishes with meat, processed meat, and or a substantial ingredient of it. So let's move forward. That case is the famous one. We have already heard about it this morning, and I'm sure that you have all heard of it. So the most important, or one of the most important questions addressed by the General Court is concerning the Article 7.3. And so, as you know, it allows to register a trademark which is non-distinctive if the acquisition of distinctive characters through use can be demonstrated in the part where ab initio it was devoid of such character. But in Chocolate Fabrik and Lindt and Sprungli Golden Bunny case, the court stated that it would be unreasonable to require proof of use of acquisition for each individual member state. So there is still questioning how to interpret that court's finding. So the Board of Appeal in this case considered that the Nestle has demonstrated that the use of contested mark in almost all the relevant territory was made. So at the time it was 14 out of 15 member states, and that almost 50% of the public of 10 member states that represented themselves 19% of population identified the contested trademark as an indication of indicating as a commercial origin of the goods. And it concluded that the contested trademark had acquired distinctive characters through use in a substantial part of the territory of the EU. So the question is whether the substantial part of the territory of the EU is enough. And before to get to the answer, at least given by the General Court for now, first the General Court reminded another principle, that the protection of Article 7.3 could be granted only regarding the subcategory of the goods of the mark at stake that the mark has actually been used for. So it found that half of the goods, so like bakery products, pastries, cakes, and waffles, could not benefit from the use of the contested mark in respect of sweets and biscuits. So, and getting back to the Lindt and Sprungli, so the General Court, unlike the Board of Appeal, considered that the substantial part of the EU was not enough, and that the acquired distinctive character should be demonstrated throughout the territory of the European Union. And it added that the relevant public was whether that the relevant question was whether it was proved that throughout the EU, a significant proportion of the relevant public perceived a mark as an indication of the commercial origin of the goods designed by that mark, and that the lack of recognition in one part of the territory of the EU cannot be offset by a higher level of awareness in another part. And as for the paragraph 62 of Golden Bunny case, the General Court interpreted it as it was giving the possibility to produce the proof of acquired distinctive character globally for all the member states concerned, or separately for different member states or group of member states. And concerning the issue of the case, the General Court concluded that although the acquired distinctive character through use of the contested mark has been established in 10 member states, the Board of Appeal could not validly conclude its examination of the basis of percentage of the public recognizing that mark in those member states, and it couldn't do so even if the population of those states represented almost 90% of the population of the EU at that time. But the question is not closed yet, because we have 3 appeals to the Court of Justice, and the Court of Justice will have to deal with the case, and as well the question of interpretation of Lind and Sprungli judgment that was unfortunately not answered in Louis Vuitton case, because there was an agreement between the parties. And to finish, I have selected 3 likelihood of confusion cases, but really briefly. The first one is concerning the perception of that mark. There was a difference of views between the Board of Appeal and the General Court. The Board of Appeal considered that earlier mark was a letter D, although the mark applied for was something like a rather geometrical figure. And the General Court had a different view, considering that the possibility that that mark was being perceived as a letter D cannot be regarded as remote, even though there are variations compared to with the classical form of that letter. But more importantly, it found that irrespective the link between D and the mark applied for differences were of minor importance compared with the similarities. It also took the opportunity to remind that in the cases when the trademarks are composed of single letter for identical or highly similar goods, as it was the case here, a special consideration has to be given to ensure that the marks are sufficiently visually distinct in order to exclude any likelihood of confusion. So here there was a likelihood of confusion for the General Court. The next case I would describe as which is the least distinctive element in this case. As to the view of the Board of Appeal, it was the element art that had a weak distinctive character in both signs. So it considered that there was no likelihood of confusion. And the General Court had a different view and considered that there was average degree of visual similarity. And what is important to note that the General Court rejected the argument based on the case law that consumers attach more significance to the beginning of the signs, saying that here it was not the case, and it pointed out that the element art will attract and retain the attention because the marks at stake were both short marks. And concerning the word element shop, the General Court found that it will be understood as the place where art goods are sold, so it concluded that it was devoid of any distinctive character for goods at issue, although the art element was weak, the court agreed with that it was weak, like the Board of Appeals said, but nevertheless it was the most distinctive word in the mark applied for, so it concluded that in the case when there is an element devoid of any distinctive character with regard to the goods concerned, it's not capable to offset even the limited overall similarity existing between the marks at issue. And so, yeah. And the very last case of this morning, it's from the last week. Actually, the task is quite simple, and the most important part of the judgment, in my view, it's concerning the dominant and distinctive elements in this requested figurative trademark, bad toro, as comparing to the earlier word mark toro. The Board of Appeal considered that in the requested mark, none of the elements were dominant, and that the element toro kept an independent, distinctive role in that mark. And the General Court took a slightly different view, saying that the dominant element in the requested mark was the figurative one because of its size, originality, and the special expression of anger of the animal. And as concerning this independent, distinctive role of the element toro, it as a reference to Bimbo Donut case, it considered that the word element will be understood as a direct reference to the figurative one, and that it will form a logical unit that will have a distant meaning from the word element of the earlier mark. Okay, thank you very much for your attention.